much, Mr. Ladi. We have some questions in the chat as well. So perhaps some questions. And then secondly, someone asks, can someone that gets an email from UKVI to look for another COS after a COS has been revoked, can ask for more time if the 60 days pass?
No, you cannot ask for more time. You can't. What you can do is to put in an application. Rather than ask for more time, put in an application, which people are now doing, called the further leave to remain, the FLR applications. You can put in an FLR application, but it will not give you more time. No, unfortunately not.
We have another question here for Mr. Ladi. They say an asylum seeker that got immigration bail, but later settled with the university and he was asked to continue his study. How can he settle his visa issue? Should he cancel the asylum application, or what can he do since he can't get another CAS? That's a CAS.
No, he can't cancel. He or she can't cancel the asylum application. He has to see that asylum application through, because there's no way for that person to then now go back to. If you can't get a new CAS, there's no way. There's no way. You just have to follow the asylum application through.
Okay. Thank you, Mr. Ladi. We have a couple of questions for you. And this person says, please, I need clarification on children's settlement rule.
Okay, so we have a set. Okay, so there are different categories of for children's settlement. We have what we call the 7-year rule, which is the most popular. A child that is born in the UK that has stayed there for 7 years can apply for settlement, irrespective of what the immigration status of the parents. The child cannot apply for. This is one mistake people make. People then go on and make naturalization. It might come true, but that's the law. Is that the child must first apply for settlement under the 7-year rule. And once they give the child an settlement, then the parents can use that to stay under the human rights law, family life.
Thank you, Mr. Ladi. We have another question for you, and it goes, my wife got a healthcare sponsor after her studies, but when he applied, he was denied as a dependent. And he said, although he is currently on a separate healthcare sponsored visa, but he would prefer to be a dependent so he can work his main profession. He can work in his main profession. So he's asking, can I still challenge the Home Office? The Home Office decision after my visa was denied last November. The visa has been denied since December.
Yeah, it can be challenged, yes. Whether that person is going to succeed or not is another question. But of course, you can challenge it. Even though now you're now on a different visa. You can challenge it up to judicial review. And there's actually now a class action against the Home Office. A class action is where everybody is suing the Home Office based on this new rule that came in April that you can't add your dependents to care visas. But going to that particular question, yes, it can challenge it, but whether it would succeed or not is another question.
So someone is asking, how do I apply after I get a new COS?
Apply for what?
Yeah, so after I get a new COS, how do I apply for it? Maybe apply.
How do I apply for a visa or I guess how do I apply for a visa?
With the person, right?
Well, it's either you can go online and apply. Just type skilled work visa, and then it will take you to. You will have two options. It will say, are you in the UK or outside of the UK? You're in the UK, and then you can apply, or you can use the solicitor. You can use a law firm to apply for you. Or you can.
And we also have a very long question here, and it says, please help me and my child. I am a single mother presently staying in United Kingdom. I relocated to United Kingdom March 2023. I basically fled for my life and my daughter's life. I was in a toxic relationship back home. I was on a student visa, but when I couldn't pay for tuition, school has reported me to Home Office. I have no one here in the UK to help me or give me legal guidance. In the process of trying to secure stay and to avoid deportation, I met a Polish guy online who promised to marry me, and he even asked me to vacate my 2 rooms apartment, and I was living with my daughter to stay with him. She now says, since I do not have any other option, I moved in with this guy August 2024. I was abused sexually. He spiked my drink and had anal sex with me twice, physically and emotionally. He also made an attempt on my daughter on the 24th of December 2024. Sometimes in October, my daughter's bottom PJ was worn wrongly, and I can't seem to understand why. My daughter won't tell me she's 5 years old, and she probably doesn't understand things like that. When school resumed 7th of January, I reported to the school on 9th of January. Social worker were involved, and they have moved my daughter and I to the hotel since 10th of January. I have reported to the police and also been to GP, which they confirmed that that's why I was bleeding from my bum as a result of what the guy did. To cut the long story short, the social worker called me today that they don't know how they can help me or my daughter because we have overstayed. I don't know any immigration lawyer and I don't even have anything. So the person is asking how she's going to go about this.
Okay, so I mean, if you come through AIS, it's not a problem. I'm so sorry for what you have been through. But what I would suggest is that you go back to AIS, and then AIS will get in touch with us. But we're more than we'll be more than happy to take your case pro bono, and help you to get what you rightly deserve. I mean, the fact that you reported to the police, I'm not too sure whether the guy has been arrested. But definitely, if he's been arrested, there will be a trial. You are going to be a witness. Your child, even though young, might be a witness as well, a potential witness. And then we'll definitely help you. Please, it's a very sad story. So sorry to hear what you've been through. But we'll just get in touch with the guys at AIS, and we'll definitely do that for free. We'll take your
We have 2 more questions. It says, please, can you speak again regarding the skilled worker salary of 23,200? I didn't get you.
Okay, all right. So it's quite confusing, actually. So I'll do this again. I think I wrote it down from. Okay, so it's 23,200. If or £11.90 if you are under 26 or if you are a recent graduate. That's the salary, okay? And this 23,200 used to be the salary before April 2024, when they increased the salary. Now, new salaries are now 30,960. So, and this is the salary if on renewal. So when you are renewing, your CUS has to bear a minimum of 30,960 or £15.88. But if you are under 26 or you're a recent graduate, so maybe somebody coming or outside of a post-study work visa, then they will allow, they term that as a new entrant, then they will allow the salary to be 23,200.
Okay, thank you for that. And we have the last question in the chat. It says, can I apply for COS after finishing my postgraduate, but on asylum applications before I finish school?
Can you apply for COS before when?
After finishing my postgraduate.
Okay.
After finishing the postgraduate, can you apply for a COS, but also on asylum application before I finish school?
Okay, so you can apply for COS before you finish your master's. Yeah, you can apply for it. The only thing is that they have to date that COS for the time that you are going to graduate. Okay. The second question is not very clear, but if I get it right, that means the person already has an asylum application, and then
I
you're
think
not
so.
asking whether I'll talk about asylum application after I answer this question. People, you've applied for asylum application. You're now asking whether you can do a COS after applying for. Well, you can technically. It depends on what kind of visa you had before you apply for that asylum application, and whether that visa had expired before you applied for asylum application. If the visa had expired before you applied for asylum application, you can't apply for a COS. If the visa had not expired before you applied for asylum application, then you can revert back to the COS. The only challenge is that the employer that wants to give you that COS might find it difficult, might find it a bit reluctant to issue the COS for you. But there's no reason why you cannot apply for COS, so long as your visa had not expired before you put in the asylum application. So I'll quickly talk about two things that usually confuses people. The first one is this issue of so say for example somebody's visa is going to expire tomorrow. Okay, if somebody's visa is going to expire tomorrow. If you make that application either today or tomorrow, you can make an application on the day that your visa is going to expire. If you make the application on the day that the visa is going to expire, and the visa decision takes maybe 1 year to before you get a decision. So long as you made an application before your visa expire, your visa is deemed to continue. So if you had a post-study work visa at that time before you made an application, that post-study work visa, the conditions that you had before you put in a new application has to continue. If you are a student, when you made an application, your work conditions that you're allowed to work 20 hours continues until a decision is made. The second thing about asylum application is that we are seeing quite a lot of asylum applications now. And to be honest with you, the only way an asylum application will work is only if you have a based on sexual orientation. Any other thing in Nigeria will not work. Female, what's that thing called? Genital, I've forgotten the term now. It will not
Genital
work.
mutilation.
Mutilation will not work because of internal relocation. They will tell you that you can, if you are saying that they do it in this town, they will tell you can go to another town. The only way an asylum application will work is if you say you practice the same sex. Or yes, that's the only way it will work because Nigeria criminalizes such acts. But to succeed in such an application is very, 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 very difficult. But I'm not saying it's impossible, but I'm saying it's very difficult. Thank you.
So we have two people raising their hands. I'm just going to give them a little time.
No
So I'll
worries.
start with Awesome OIK. If you can unmute and ask your question now.
Okay, can I speak up, please?
Yes, please.
Well, with you.
Okay, this question is on behalf of my brother. I'm currently here in UK. The question goes this way. He has been here as a student since 2021, and his student visa was like that should be 4 years, and he did foundation program. And before the foundation program runs out within a year, and after that he couldn't continue because of tuition fees and all that. And now he has overstayed, and currently he has filed an application in the Home Office, and he is married to a British citizen and with a child as well. But now they are onto what they call what do you call it again? Into what they call like the daughter now is like a stepdaughter to him. So now he's Now he's what they call what they call what they call it again? Like he was refused at the first time, and now they are further what they call appeal to the judiciary. So the question now is that now he has forwarded to the judiciary now and is in appeal. Is there what is the rate of percentage chance that he's gonna get it this time around? Because at first it was refused, saying that since he's an overstayer and he came under a student and he didn't have any plan to stay more. So applying for this. But now the question now is that he has every legal documents and applications that shows that he is married to the British, which is by what they called marriage by approximate, like whereby the court in your country agrees that this marriage is legal in the UK, and that's how it's done. So what is the chance that this appeal?
Hello? I think I get the question there. Sorry, Lola, can I reply? Or?
Hello? Hello?
Yeah, I can hear you.
Yeah, so did you get what I said earlier?
I did, yes.
Yeah.
Do you want me to answer now, or you have more?
Yes, I'm done.
Oh, okay. So the chances are quite slim, and I'll tell you the reason why the chances are slim. Number one, the first reason is because the child, if had it been the child was biological child, that would automatically they will allow him to stay and put him on a 10-year route to settlement. The second reason why it is going to be difficult is that, in fact, there are three. The second reason why it's going to be difficult is that when they go on appeal, the argument of the Home Office will be that we're not saying the marriage is not genuine. We're not saying that at all. And we're not saying that we can't allow this person to stay in the UK. However, this person should go out and go and apply to come back in. That would be the argument of the Home Office. And the judge will buy that argument. The judge will just say, look, is there any reason why you cannot go back to your own country and make an application to come in? Why do you want to jump the immigration queue? Why don't you want to do the right thing? So that is the main reason why it will fail. The only defense to that, if the Home Office comes up with that argument, is that if your brother now says, look, if I go back to the Nigeria, it's going to cost me extreme hardship. If the judge can be convinced that it will cost him extreme hardship, and there is no benefit for the UK public for him to stay in the country and make an in-country application rather than going back home to go and make the application, then it will work. But for you to show the judge that you will face extreme hardship is very, very difficult. It's extremely difficult.
Okay, sorry. Okay, according to him earlier, that's what UK government apprehend and accepted the type of marriage he did. I don't know the name he call it again, but
proxy marriage. They don't accept proxy marriage from Nigeria. Are you from Nigeria?
Yeah, he's from Nigeria, exactly.
Well, they don't accept proxy marriage from Nigeria. However, you don't really have to be married to qualify under the spouse route. If you can show that you are in a relationship, you've been in a relationship for 2 years, and that you've been living as we call it akin to marriage, as if you are married, then that's fine. So when they go to the hearing, if they can show that they've been living for 2 years, it doesn't matter whether they are married or not.
Yes, that's where the question is coming from, because according to him, he has done everything needed. They have been together for about 2 years. And he have proven to the Home Office with the legal documents of proof of address that they have been living together for this period of 2 years, and in a proof of statement every month, every year that shows that they have been together all throughout the 2 years. And they has letter from the GP, the legal documents covering all of this, and still he gets refused. But now he files an appeal.
Well, you know the Home Office, I'm sure in that refusal letter, look at the refusal letter very well. They're not saying that their marriage is not genuine. They're just saying that he's an overstayer and that he cannot do an in-country application. That's what they're saying. They're not. When you go to the tribunal, they won't attack the marriage. They will in fact say, look, we agree that the marriage is genuine. There's no problem about that. But let this guy go back to his home country. Let him apply to come back in as a spouse. But we're not going to treat the application in country because there's no reason why we should treat the application in country. Because the argument is that people, if they start treating applications in country for people who are overstayers, it will encourage a lot of misuse. So that will be the argument at the tribunal, and the court will buy it, unless your brother comes up with reasons why, if he goes back to Nigeria, it will cause either him or the partner hardship, and it has to be extreme.
Okay.
Yeah.
Thanks a lot.
No problem.
All right, we have two more questions from the chat. I'm just going to read it now. And it says, if a new COS application was made after 5 days of existing visa has been expired, can the application be granted? I think we have answered the question.
Yeah, it can, because it's less than, but you have to give reasons. If you don't give reasons, they can refuse it. You have to give reasons why the application is late, and it has to be genuine, and it has to be compelling reason why.
Okay. Yeah, the next one says, please, can you explain the part of the difficulty of the asylum of same-sex visa application? Because I have someone who is already processing it. Same-sex visa application.
All right. So thank God the Home Office would not say, we want you to prove to us that you practice same sex. But what they will tend to do is they will tend to attack that person's credibility during the time that they are questioning that person. And they go about this attacking credibility by asking questions. The first thing about credibility is that if your visa had expired before you go and claim asylum, it affects your credibility. So if you are starting your credibility at 10, and then you go and ask for asylum after your visa has expired, or after they've curtailed your visa, it drops down your credibility to 5. And then when you then go for the interview, they then start asking you questions pertaining to your sexual orientation. So do you have a partner? When did you start practicing same sex? I have a client who they asked him which kind of, does he frequent any clubs, and then he mentioned some clubs. And they know all the clubs. They asked him that. They already know when he was coming for the interview that he was living in Manchester. They know all the same-sex clubs in Manchester. And then he mentioned the same-sex club. And then they started drilling. They said, how long have you been there? He said, I go every weekend. Okay, what is the color of the door? What kind of lights? What kind of music do they play there? Where is the bar located? And he messed up in all those things. So usually it is your credibility that they go for. And any attack on your credibility would destroy the claim. So that's why it's very difficult. And another reason why it's very difficult is that they know that people are using that to try and want to stay. So when you make that application, they already have it in their mind that you're lying. So or they already have it in their mind that this is a false claim. And so you are up against, even if your claim is genuine, you are up against somebody that already made up his mind that this person is just trying to play fast one on us. But it's not impossible.
Thank you very much.
That gets it. So.
Yeah, this will be our last question for today.
Thank you very much.
And this is for the main applicant with a 4-year work visa. At what stage should the person apply for extension or ILR?
Well, you can only apply when you clock the 5 years, but you can apply 28 days before you clock the 5 years. So they give that 28 days allowance before you clock 5 years. If you have a 4-year COS, well, you have to apply for another 1-year extension, don't you? To make that 5 years. Yeah.
Thank you very much for that. And I will be passing. Thank you very much, Mr. Ladi. We really appreciate this session. We've really stretched you a bit. Well, we appreciate that. So I'm going to pass this to Mrs. Aisha to tell us some support service and support services that we offer or we render in African immigrant support. Thank you, Mrs. Aisha. Over to you now.
Thank you very much. Again, a very big thank you to our solicitor. We understand your time is very valuable, and we really appreciate you giving us time to answer these questions. Thank you, sir.
Thank you very much. Thanks for having me.
Yes. So, like I said in the beginning, we are here to bridge the gap between challenges and opportunities. And we understand that there are a lot of legal issues, a lot of immigration issues, and a lot of other personal issues. So because of that, we're going to be having an open day where you can come into our offices and have you speak to experts that can help you with whatever issue that you have. This will be happening on the 28th of February. Between 10 a.m. and 4 p.m. You're free to either come in or call in and have your issues heard. But you do have to book because we will have limited time because our consultants are very busy and their time is incredibly valuable. So do make sure you book your spot before time, and hopefully we'll be able to continue to help each other in bridging that gap. Thank you very much.
Thank you.
Thank you very much, Ms. Aisha. Thank you, Mr. Ladi. Thank you, everyone that joined. We'll be coming to the end of the webinar now. So like Ms. Aisha said, if you have any question or further inquiries, you can always reach us through the email. We have WhatsApp number, we have helpline numbers where you can reach us at any time, and we'll get back to you on whatever issues we have and in any way we can help you. So we'll be, I think somebody's asking for, okay. Yeah, the location is just on the flyer. We will send this to everyone present here today as well. You receive it. The location is 8 Warren Yard, Wolverton Mill in Milton Keynes. That is MK125NW. But we'll be sending out a slot for everybody to book their slot, because you won't just come and meet us. So you have to come at your particular given time. Thank you very much for today, everyone. We appreciate you coming. We appreciate your time, and we hope this is very valuable to you.
Thank you.
Thank you once again.